we get asked a lot of questions, and one of the things that's come up that we thought was really intriguing to talk about is, what do people need to know in order to give good testimony and to present their story well and to be a good witness?
Yeah, so this is a perfect example of somebody who made a comment on one of our clips and asked if we could do an episode on what would make an accused witness or a good defense witness. And here we are talking about it.
So we've got a top 10 list, and then we'll go through each of the little bits.
We've been doing that lately, a lot of holisticals.
I know, but they're fun. It's a good way to break stuff down. And so just as a little preview, I guess, we're going to talk about your demeanor and being eager to answer questions, the need to listen to the questions carefully. Don't worry about why you're being asked the questions when it's the prosecutor in cross-examination.
Yep.
Make admissions against interests. And, don't try to paint yourself as some sort of saint or something like that. Be emotive, but don't go bananas.
Right.
Be consistent, but admit when extra details are added, right? So, don't, get evasive or double down. Don't put your character on trial. That's a big one that we come across a lot. Be very careful about the date of fabrication when if you're saying that the complainant's made up.
If alleging a motive to fabricate.
Yeah, if you're alleging that. Don't try to guess what the complainant was thinking, because you can only testify about what you've seen and heard. And which ties into number 10, which is don't engage in possibility questions, which is a bit of a trick. And we'll get into these in details, but don't speculate on things. Just stick to what you know and what you saw and heard. All right. So going back to number 1, demeanor and being eager to answer questions. People can, and it's understood by judges if people are really nervous when they testify.
Yep.
And that's not going to adversely affect your credibility. They expect people to be nervous, but you don't want to look defensive, leaning back and crossing your arms and stuff like that. And it's not really just a matter of body position. You want to show and be eager. This is usually for most people the first chance they've had to tell their side of the story.
Yeah, so we often encourage clients when testifying to sit up straight, lean forward in the witness box, make eye contact with whomever is asking them questions. And, as we try and get across to them, this is your opportunity now to get your evidence out. And it's very important to be eager to do that and answer things, as we normally would say, in a straightforward manner. But have that degree of assertiveness and eagerness to give your evidence. Mm-hmm. And that's important. And we talk a little bit about demeanor, and we'll make a comment about it a bit later, but it comes in to another number. But I think it's very important for people to have the correct physical presentation. Mm-hmm. And, it's important for clients to dress appropriately.
That's what I was going to say. Speaking of which, don't go in there dressed in jeans and a t-shirt. You want to show that you're taking this seriously and understanding that this is your life.
Like you're going to a job interview, or you're going to, a place of worship, be in a suit, shirt and tie. And like you said to somebody, if it's a dark navy suit, don't wear white socks, or Joseph will explain in great detail why that's not a good thing.
We'll have to listen to that.
Yeah, but no, dress like you're engaging in something serious. It's the solemnity and respect for the court.
So listen to questions and answer the actual question. This
seems easy, but it isn't.
Yeah, I know. And I think that's because sometimes people start to guess what the question's going to be. And so they're busy thinking about how they're going to answer it without listening to the full question. And so, for example, you might be asked a question about when something happened, and they answer a why question, or the reverse, or something like that. So it's important to, and you can pause, and you can ask for the question to be repeated if you're not sure exactly what they're asking.
You can ask for clarification or to repeat it, yes.
Otherwise, you shouldn't be asking questions when you're on the stand. But no, you can ask to clarify it. It's important to be direct. Otherwise, you could be seen as evasive when you're asked one question and then you're speaking, using that as an opportunity to tell a different story.
Right. So it's very important, as we say, listen to the question and answer the question. Don't go on a tangent. It's very important to be direct and straightforward in the answer. Now, sometimes a type of question will be presented that allows the accused to go back and repeat a bit of their narrative in order to give proper context to the answer. that is fine. But be succinct and be direct. A bad witness will then kind of reshape what the question is about and answer it according to whatever they want to answer. And if they do that often enough, the witness will then lose credibility. So it's very important, of course, in examination in chief. It's easy when we ask a specific question, the clients understand where we're going and they know how to answer it. But in cross-examination, that's where this becomes a big issue. Listen to the question and answer the question.
And we're mostly talking about cross-examination, but just as you mentioned...
But in examination in chief too.
Yeah, in chief means that when you're called, if you're the accused, the defense will call the accused as the witness and ask questions, which is the general storytelling. And then they get cross-examined, which is the same of every witness. The complainants get called by the Crown or the prosecutor if you're in the States, and then they get cross-examined. Then the next witness is called, and then they're cross-examined. It's the process with every witness. So we're mostly talking about cross-examination.
We are, but I want to emphasize, and we work with our clients on being a good witness in court and what it means to testify. But sometimes it's an issue, even in our own cases. When we're calling the evidence, it's important for the accused in direct examination by your lawyer to listen to the question and answer the question. And that is sometimes a product of being nervous, because we say often it'll get easier once you're a few minutes into the process, but they can be very nervous. And if somebody's nervous and they're having a hard time answering or hearing, they can say, I'm sorry, can you just repeat that? I'm very nervous. This is difficult for me. That doesn't hurt you.
No.
You're a human being. You're not a professional witness. Your life is on the line. If you're nervous, that's fine. Whether it's exam in chief or cross, you can take a moment to compose yourself, and if you want clarification, you can. But the key is to listen and answer the question asked.
And that kind of slightly ties into the third one, which is people worrying about why the prosecutor is asking a question and assuming that the prosecutor is trying to set them up in some way. And, quite often, they sincerely just want to know the answer to a question. Sometimes they actually ask open-ended questions, and it's not a trap or something like that. I mean, obviously, sometimes you can see a theme in what they're trying to say, but and there's a few interesting, tricks. Maybe we'll get into that when we talk about the possibilities.
But I think this is an important point, because listening to the question and answering it in cross-examination flows into, don't worry about why the prosecutor is asking you that question. A good, skilled cross-examiner, Crown attorney, will have a theory that they're going to litigate through cross-examination, but witnesses can get caught up as to what the Crown is trying to do. Forget that. That's not your job.
Just listen to the question.
Just listen and answer the question. The more direct and succinct you are in cross-examination, the better your credibility.
Yeah. And so the next one too, again, a lot of these
Number 4.
tie together. It's kind of summarized as be humble. So
well, I like the way
make
it's written
admissions
here.
Against interests
When appropriate.
When it's appropriate, and that means if you happened to have drank a lot on a certain night, or were struggling with certain kind of problems, admit that you had those problems. If you things that you might worry about, saying like, oh, well, if I admit this, and it might make me look a certain way. It's like, if you're honest about it, making admissions against your own interest, things that aren't necessarily, noble qualities and stuff like that, brings a lot of credibility.
Well, yeah. So, for example, let's do an example. It's a domestic case, and domestic assault, along with some other things, and it happens within the course of an argument. And Crown is asking questions, and we'll do this in examination in chief to blunt it, period. But we'll go, how are you feeling about that? Were you upset? Were you angry? And sometimes a witness will say, well, no, I wasn't angry. How could you not be angry? The content and context in which this argument is occurring would make any normal human being angry. So if you deny the obvious, then you're going to look not credible. So you want to make it admission. So if you're in a heated argument with somebody and you're alleged to have hit them during the course of that argument or assaulted them, you can say, yeah, no, I was angry. I was really angry. No, I was yelling. I called her names. That was terrible what I did, but I did. I was completely angry, but I didn't hit her.
Right.
So making an obvious admission about what is truthful about your own emotions during a particular event, or like you said, if you drank a little bit more than normally, or whatever, you were speeding at that time.
Suffering from depression,
These are just
all
natural
kinds of things that people might not want to normally tell anybody in public, especially strangers.
But being honest and forthright about your emotions lends credibility to your overall testimony. If you try and paint yourself as an angel, like you said, it's not going to fly.
And then we have number 5. So be emotive, but don't go crazy.
Don't go bananas.
Yeah, don't go bananas. And
let's talk about this for a little bit, okay?
So, we've had people before who came across really robotic on the one side of the scale. And it's because they were sort of analytical in nature, sometimes like computer type people and, academics.
Are you stereotyping?
Well, it tends to be a pattern more so that
there are some people who are very clinical in their jobs, and they come out very clinical in their presentation.
Yeah, they live in their head, and so they don't speak with the same kind of inflection and stuff like that. And so it takes a little bit to get them out of their head and realize that, okay, no, you have to tell a story, like your story. And then other people have just been like so angry at the charges and stuff, and they want to make it clear how angry they are. And we've had somebody pounded the table so hard that we had to take a break. Yeah.
Yeah, we've had you have to walk a line between being assertive about your innocence and denying the allegations and not going too far, because we've had some clients who've exploded, but to be fair, sometimes a judge might not draw a negative inference from that. They might go, well, if I was accused of something like this, I might be just as angry. Mm-hmm. But there still has to be a fine line about not going over too much, because, the angrier somebody gets or loss of control can feed into a Crown narrative, and it can feed into the allegations. So you have to be careful. And
especially if the charges involve accusations that are violent in nature.
Right. But we have to remember that the Court of Appeal has made it clear that it is not safe to give undue weight to demeanor evidence because of its fallibility as a predictor of accuracy of a witness's testimony. Demeanor is of limited value because it can be affected by many factors, including the culture of a witness, stereotypical attitudes, and the artificialness of and the pressures associated with a courtroom. So demeanor is a factor. It's by no means determinative. And reality is that it is quite a fallible predictor. That said, we always do believe that an effective witness will be one who is assertive in their denial of an allegation and assertive in their evidence. And that also meshes with how you give your answers as well. Like, you're going to go back to your narrative, but you want to do it as a direct answer, but you want to explain. And I think that's very important. So you have to some extent, take control of cross-examination and look at it as another wonderful opportunity to get your evidence out there. So
that's I think one of the big things to always have in mind is that this is an opportunity to actually be heard.
Right. And the flip side is a certain case may make somebody very emotional. Mm-hmm. And they can be very upset and cry in the stand, male or female. And when they're, it can be a case involving parental alienation. They're watching their child make accusations. They haven't seen their child in 3 years because of the matrimonial case. It's terrible, or other circumstances, not those necessarily. But if a witness is sad and is emotional, that's okay too. It's a natural human emotion. When you're testifying, all this is going on in somebody's head, so their psychological and emotional makeup will come through. That's fine too.
But there is a certain decorum in the courtroom, which, when you're present, you kind of get a sense of it right away. When the judge enters, you have to stand up. The lawyers call each other my friend. That's intentionally done to try and keep things on a more even keel and to try and keep some politeness to the environment.
Well, and then when we had a case where our client was getting a bit rough with the Crown, stopped himself and said, "I'm very sorry. You don't deserve this. I apologize." Mm-hmm.
Yeah.
So this was good. Literally stopped himself and said, "I'm sorry." I literally said, "You don't deserve this. I'm just very upset, but I'm really sorry." Yeah. That was good.
Yeah. But it's it's part of the process too, and it is a scary situation going into court. It can be intimidating for
Horrible.
people who aren't even necessarily part of the trial. It could be intimidating to be in a courtroom.
It's very difficult. We always have to remember, for any witness to testify, it is a new and strange forum, and it's difficult, and there's lots of factors that impact somebody, especially, complainants and accused people. It's very difficult. So nothing we're saying is easy. We realize it's tough.
And so when we have number 6, be consistent, but admit, if extra details are added. And, it's a natural result of cross-examination so you, like we mentioned in chief testimony, you'll tell your story to, the defense lawyer, if you're not self-represented, that you'll, tell your story first and then get cross-examined. So you want to keep focused on the details. If you're moved around in your timeline of things and the questions are being asked out of order, just focus yourself on, and you can say, like, I'm sorry, when are you talking about? So you want to, consistency is, I think obviously quite important, but when you're being cross-examined, they may ask, well, why did you do that? Or and ask for extra details. Well, why didn't you say that, at the beginning? So because it didn't seem necessary. So it's important not to get tripped up when you're asked for more detail, and then you do add more detail, than being accused of not having said that detail before. You know what I'm talking about?
Yeah, so let's break it down a tiny bit. So consistency is very important for a witness to be credible, and that can refer to consistency in your answers in your testimony compared to maybe if you gave a previous statement, or internal consistency when you're testifying. So when you testify with your lawyer and you give what we call the examination in chief, and you give your version of events, and then when being cross-examined, you must remain consistent with what you said in your examination in chief. If you have forgotten something, or you add additional evidence, factors, that comes out through the cross-examination, and the Crown goes, well, you didn't mention that when your lawyer was asking you questions, you can say, you're absolutely correct. Yeah. I didn't remember that, but now that you mentioned it, I do remember that. Mm-hmm. But you have to be fair about what you did not say, and don't try and play around with it.
And it does sometimes happen that that the cross-examination will suggest that something different was said in testimony, but that's not actually what was said. That does happen sometimes as well. So sometimes you can be accused of an inconsistency
and it didn't
be
happen.
Like, well, if I said that, then that was an error, because that's, what my testimony is this other thing.
It's okay for an accused to say, I'm sorry, I don't remember saying that. If I did, then I would have been wrong. But my recollection of when I was answering questions to Mr. Neuberger or whoever is this. But, I don't, if I did, then...
That's not always like a trick. So sometimes
it can be. But
but sometimes people honestly just think that they heard something different. And if you were to go back to the transcripts or the audio recordings, you'd say, no, that's not true.
Yeah, and so, Crown attorneys don't always know what an accused is going to testify to. In motions where we have 276, 278 applications, we give generally an outline of what the client's going to testify to, so a Crown will have some understanding what the evidence is. But in many cases, they don't. So a Crown attorney in prosecution will often, in cross-examination, go through the evidence in a different order, or go over and repeat it and repeat it and repeat it, trying to draw out these internal inconsistencies. And that's why, and it can be tiresome, but that's why the witness has to remain calm, succinct, and try and be as consistent as possible. Yeah. And we need to remember something about assessing evidence, but go ahead first.
But, having your timeline and your sequence of events locked into your memory is sort of like a skeleton of what the evidence is, as opposed to trying to remember words that you want to say and stuff like that. This is the most important thing with cross-examination, because then if you understand in your timeline where it is you're being asked to go, then you can just take yourself to that part of the timeline and handle the questions a lot easier.
So it's important to also remember that there are, material inconsistencies and more minor peripheral inconsistencies. So where an inconsistency involves something material about which an honest witness is unlikely to be mistaken, the inconsistency may demonstrate a carelessness with the truth about which the trier of fact should be concerned. So certain sort of hallmarks of what you're testifying to in your evidence, which are crucial to your evidence, those are not things that you should be making mistakes about. So it's very important to remain consistent on all of the important factors. There may be some minor ones that you may slip up on. That happens to complainants, happens to accused. Those are of course what we call minor and more peripheral. But the more internally consistent you are, both in chief and in cross-examination, the better. The other thing you have to remember is, and we keep coming back to say this because Supreme Court of Canada in 𝐸𝐶 talked about common sense. And so consistency and the way you present your evidence about how things unfold, that there is a natural, organic unfolding to your story as you're giving it out in evidence is really important, because a judge, in doing an analysis on testimonial assessment, is basically inductive reasoning and the particulars of the case. It requires a trier of fact to make assessments based on probable interpretations of the evidence. It is therefore necessary for a trier of fact to depend on certain life experience to make informed common sense inferences from what they have before them as evidence. And that is now allowed. For a while, common sense was a bad word.
Yeah.
And we've spoken about this before, but the 𝐸𝐶 decision brings it back, and sometimes judges will rely on ungrounded assumptions about human behavior in their assessments, and that can occur. So what's important is, and why I say this is, when we're talking about the consistency and giving your evidence, there's also a flow to that evidence. And so we didn't have it itemized separately, but there should be an organic, natural flow to how the witness describes the unfolding of events.
Mm-hmm. So yeah, give that flow, tell the story in a logical, coherent
yeah,
and more chronological fashion up front, and then be able to go back into those things. But the flow is important too. They're not jumping around and
but that's
make points out of order and stuff like that.
But that's why I say when a witness is cross-examined, when an accused is cross-examined, and a Crown attorney is going out of order with facts, it is okay to go back and say, I'm sorry, no, this is what happened first, this is how this unfolded, and then this. So that's not a problem. That's not listening to the question and answering it. That is giving proper context to your answer, and you're allowed to do that.
And generally, you'd answer the question first and say, just as a reminder, this is what I had said, and this is the way I recall it.
Right.
I like the next one. Number 7, don't put your character on trial. And this is a big thing that you've said over and over again, and you're really good at explaining it, but it's an important point.
I would never do such a thing. That's not who I am. I wouldn't do that. That's immediately putting your character on issue.
I've got 5 people who say what a great person I am.
Yeah, just answer the question. No, I didn't do that. Mm-hmm. Did you break the window of that community center? I would never do such a thing. Just say, no, I didn't do that. I absolutely did not do that. Don't put your character on issue.
And I got a good example from a case that's really recent, actually, in which the testimony of the accused was summarized like this. His demeanor was different in cross-examination. At times, he raised his voice when answering questions posed by the Crown. He did not always answer the questions, but instead answered what he wanted to answer and became argumentative. He responded at one point that his surname was really big in the country that he came from, and that the Crown should go Google a family member, and who was a national hero, and repeated that he was a Christian, his mother was a Christian, and this seemed to infer that he was not the type of person to disrespect a woman. And when later asked to comment on the complainant's level of intoxication, he said that the Crown was asking a tricky question. And when pressed, said that the Crown was trying to make him say something that wasn't right. So this actually...
Not good testimony.
At this point, this kind of summarizes all the things that we've just talked about, but it also highlights this whole reputation thing too. It's like, I come from a good family, you should go Google my relative, and all this other stuff is like, it is grandiose, and it's not helpful, and it opens you up to being cross-examined on your character.
So let's take a recent example of a judge who assessed accused evidence, and this was good. The accused was a good witness at trial. He answered all of the questions put to him by both counsel, very directly, very succinctly, and very clearly. He, without hesitation, made several admissions against his own interest. that he could have easily returned home from dinner with his father in time to sit with and share some drinks with the complainant on the night in question, that it was common for him to drink scotch with the complainant, that he may very well have drank alcohol with the complainant on the night in question, as just 3 examples of those admissions. Very important. So he, without hesitation, made several admissions against his own interest. These are hallmarks of an authentic, honest witness.
I said just a moment ago too, is like when you do put your character on trial, then it does open it up for them to say, oh, well, you know, you're such a good Christian. Well, I happen to have a witness who can say that, you know, they can do rebuttal evidence.
Well, yeah, it doesn't happen to us often, you know, and fortunately our clients don't do this generally. But if you do put your character on issue, you have to remember there can be stuff out there that you can be challenged with about that. And it's just not, it doesn't resonate well with a court. It just doesn't. Mm-hmm. So the next
actually,
3.
There's a corollary there that we always say too, is like, be honest about, you know, the complainant as well, in terms of not demonizing that, you know, people have been in like...
Well, be balanced. I guess we should have added this in as well.
Lengthy relationships.
Be balanced.
Yeah, be balanced, because, you know, at the end, people can be in a relationship with somebody. Clearly they were in the relationship because there was something about that person they liked. And then by the time they end up at trial, it'd be like, this is like a demon witch or something like that. And they just have nothing nice to say. And it's like, you know, it's part of the honesty thing too, is just to, you know, to make that admission. Yeah, okay, there were things about her that I really did like. That's why I stayed for so long.
Yeah, no, we often talk about that. You know, everybody is not completely evil. Everybody is not completely good. So when a witness is testifying and giving a background, for example, about a relationship, they can say, yeah, no, I mean, I found the person, you know, attractive. They were intelligent. We laughed a lot. We had a very similar sense of humor. Unfortunately, the relationship started to deteriorate, and then you get into an explanation about it. But, you know, you have to be honest about these things, because that's what brings credibility to it. You know, it's like a sexual assault case. It's so funny sometimes. No, I wasn't attracted to her. You know, this was like a one-off or a date or something. I wasn't attracted to her. Okay. It doesn't help. You know, it's like, yeah, no, we had one witness. It was very funny. Said, no, I was having the best day of my life. You know, like I was totally thrilled. I thought this was great, you know. And that was like, even the judge laughed, because the judge was like, yeah, I believe this guy, you know, like he felt so lucky and so happy, but he goes, I didn't sexually assault her, but I was having a great time. Yeah. You know, so that was pretty funny.
So this is a bit of a tricky one for number 8, is like, be really careful about the date of fabrication if you're alleging a motive to fabricate.
Yeah.
And that can get really complicated, because in legal terms, it's called, you know, recent fabrication, where they can then bring in other witnesses that can say, no, I was told about this at a prior date.
Right. So,
even though it doesn't have to be recent, like, you know, currently recent. It could be just something, you know, prior to whatever you're alleging.
Yeah, I mean, you know, you can have an allegation which doesn't go to the police until 2 years later. Mm-hmm. And, you know, maybe the theory is that just before the person went to the police, something happened that is the motive to fabricate.
They started dating a new person.
They
started talking about divorce.
Something, right? I found that you know, my partner had, you know, got a letter from a family lawyer, and they hired a family lawyer. Whatever. You have to be mindful when giving your evidence as to what your actual evidence is and how it has import. Mm-hmm. So, you know, if you're trying to ascribe to the complainant a reason for them to be lying, be mindful of what the evidence is, which means know the case. And we go through great pains, and I don't mean that in a bad way, but you know, it's very important for the client to be as involved in the case as we are, and to be meticulous. And sometimes we have to really, yes, there's an emotional element to it, but we really got to get the client involved in understanding the entirety of the evidence, because that will make them a much more effective, capable witness.
Mm-hmm. Now, I mean, that being said, if a motive to fabricate and a cause of that motive is offered to the court and they don't accept it, it doesn't lend any credibility to the Crown's case. It just takes that off the table for the defense.
Right, but if an accused testifies that, you know, the day before she went to the police, we got into a massive argument, that's why she's lying about this, and then there's evidence that they had a diary Okay,
Right.
and that diary came out, and that diary is chronologically putting in details of abuse that occurred over the course of a year and a half. You know, you've obviously forgotten about that piece of evidence that went in, and you just got angry and you're just saying this, and that will detract from your testimony. Be mindful of the entire case, and lawyers work very hard to try and make sure that the client understands the entirety of the evidence, and that, again, it's like in basketball. If you want to be an effective basketball player, I didn't play hockey, but an effective basketball player, you can, these really good guards who are controlling the play can see the floor. You know where all the players are, right? Mm-hmm. You can anticipate where somebody's going to go when you're making that pass, or what you've got to do. So, I say again to clients, you've got to see the floor. You've got to know the evidence, because when you know the evidence in entirety, no matter what the Crown asks of you, you should be able to answer the question. You're always going back to the truth and knowing what the evidence is.
Mm-hmm. And, just because there might be an incident that seems like a really good motive, it doesn't mean that something wasn't said earlier, that it could have been fabricated much earlier and you just didn't know about it. So they might have a witness to say, no, I was told about this on a certain...
Right, but
it doesn't mean that other event didn't happen. It just means it's not necessarily
it factors in differently.
So don't hang everything on that one.
Yeah, it factors in differently. And you will be going through this with whoever your lawyer is. We'll be explaining this to you and going through it. And the law around fabrication is something that the lawyer deals with in legal argument, but it is a factual-based issue as well. But the lawyer will go through it. But I guess the best thing is be mindful of what the evidence is and what your evidence is. Mm-hmm. So 9.
9, don't try and guess what the complainant was thinking, and that kind of ties into motive as well. That it's and this can happen. Sometimes the prosecutor will actually ask you what the complainant was thinking. When you arrived at the bar, how was she feeling? And it was like, well, she seemed happy. You can't say what she was feeling. You can't say I knew she was happy, but you can say she was acting happy. Yeah,
you can't testify on behalf of what a complainant or another witness says, because you're not able to climb into their mind and do that, and you're not a mind reader. All you can say is, if you're in a position of having to, and if questions are framed appropriately, you can say, well, this is what I observed. So when we were being intimate, she was laughing, she was moaning at a certain point, and we were cuddling and we were hugging. So you're recounting observable indicia that would then indicate what her subjective emotions were at the time, but you're not testifying as to what they were actually thinking, because you can't do that. But some people try and do that, and you've got to be very careful.
And with the minor exception that, if there's an argument or a conversation later and the person literally tells you what they were thinking or feeling, then you can say, well, I was told.
This is what you told me.
This is what you told me.
100%.
So and that kind of ties into number 10. And this one I find kind of interesting in terms of people who are really anxious about being cross-examined. Don't engage in possibility questions. Stick to what you know, saw, and heard. So
this is a very important point.
Yeah. So the way a question is framed, sometimes, like we've kind of covered a few examples, but you may be improperly asked what somebody was thinking. But a big one that we see a lot is, well, is it possible that that this other thing occurred that you didn't notice? And to phrase it that way is kind of interesting.
Is it possible that she was crying?
Is it possible that something happened you didn't notice? Well, if I didn't notice, well, then I didn't notice it. Is it possible? Sure, it's possible, but it's not something I observed, right? So there's different ways to handle those things. Is it possible that you were, more angry than you realized? Yeah. So but the possibility question, I do see that as a bit of a trick, because each side has their theory and their narrative they want to put forward, and then you have to put that theory to the person that you're questioning. So for us, if we have an alternate story and the complainant finishes testifying, we have an obligation even to put our theory to that person, and the Crown has the same obligation as well. But it can get into that weird phrasing about possibilities, and I always see that as a trap and be like, sure, lots of things are possible, but I can just tell you what it is I saw.
Yeah, I mean, you can have in sexual assault cases where a witness, the accused is being cross-examined, and the cross-examination is, well, is it possible that in fact, you noticed that she was crying? Mm-hmm. Or certain things that the Crown wants you to say as a possibility that would then support their ability to say that there was no consent. You have to be careful to go, well, I was paying attention to her, but if there are certain circumstances where you're unable to observe something, the better answer is to say, I can't say exactly because all I remember is X, Y, and Z. Mm-hmm. Be mindful of the evidence again, the question you're being asked, and answer it. And what you're trying to say is don't get into speculation.
Right.
Be careful not to speculate. There may be circumstances in which a question can be asked, is this possible? And you might say, yeah, anything's possible, but this is not what I remember.
And then another thing is kind of related but a little bit different is when a question is repeated as if you haven't answered it. So you're asked a question, you answer it. Then you get asked the question again.
Yeah, that happens often.
As if you didn't answer it, the way that they expected or something, And we've had that where they can be asked basically the same question 4 or 5 times.
Mm-hmm.
And
I don't object.
And and it is tempting to think, well, why are they still asking the question? Did I not answer it? I thought I did. And then people will start coming up with different answers. Right. And then, of course, it's like, aha, now I've got a different answer. It's like, only because you asked the question 5 times. So, don't worry if you're asked the same question a number of times. Just say, I think I've already covered this at a certain point when it's 5 times.
Look, if it becomes abusive, I'll stand up and cross-examine. But I like to have my client be able to defend themselves. I like my client being able to handle cross-examination without me interfering too much. I like to see that. So if the question is asked 2 or 3 times or 4 times, remain consistent. You know what your evidence is. Answer again. Yeah. You don't have to be pressured into giving a different answer because they're asking the exact same question again, only in a different format. Answer it the same way and don't get angry. Just go, I don't know, the timing of something. No, it was 8 o'clock. No, it was 8 o'clock. No, I'm pretty sure it was 8 o'clock. Yes, it was 8 o'clock.
You don't, as opposed to going, oh, well, it might have been like 1:45.
Maybe it was 9:30, no, just.
And that kind of ties into wondering why they're asking the question, because sometimes you can start thinking, I don't know, do they have something with a timestamp that shows that I'm off by 15 minutes?
It could, but again, that's the benefit of disclosure. We know what their case is. But, there can be some instances when the Crown is walking you down a path to try and get you to give certain evidence that may make you be unreliable. Stick to your evidence. Keep that internal consistency going. You know what your evidence is. Just repeat it. Be polite. Don't get upset. I've seen people say, well, you've asked me that question multiple times. Just answer the question. And at a certain point, the judge will cut it off, or the defense lawyer will stand up and say, I'm sorry, this has been asked several times.
And we have seen, too, that, there's breaks. There's a break in the mid-morning. There's a lengthy lunch break. There's an afternoon break. So it's not like you're going to be there for 6-7 hours straight and being interrogated. And, but we do see people get tired where they start out. It goes
a whole day.
Yeah, and they start out and they're they're eager to answer the questions. They're really good. And then you can see them getting tired and they start getting a little bit more fuzzy. And if it's really hard to focus, you can actually ask for a break.
Yeah, and this is where there's a slight imbalance. So I can notice if I'm doing a 3, 4, 5 hour cross-examination, and by the end of the day I can see that a complainant is getting tired and
emotional
and it's becoming an issue. I can say to the judge, look, it's been a long day. I want to make sure we get the most accurate evidence out of Miss such and such. Maybe we should get a break, or we should adjourn until tomorrow. But sometimes it doesn't work that way for an accused.
Yeah.
Right? And a judge might notice that an accused is tired, depending upon, how the day has gone, and might say, well, maybe we should stop for the day and start fresh tomorrow. Because it's human nature, if you start out at 10 o'clock in the morning and you're being cross-examined, now it's 4:15, you're going to be tired. You may not be running on that same adrenaline you had. So you can say, I'm sorry, I'm getting a little tired. It's been a long day. I think that's okay. Mm-hmm. But remember, our opinion is the emphasis on an accused testimony is held to a higher degree of scrutiny. And the emphasis there is to make sure that you really stay on top of your game as a defense witness. You've got to really, the pressure's on. You got to really try and meet that moment. Know your evidence, answer it, try and remain consistent, try and remain, appropriate in your demeanor and respectful, but assertive. And you got to do that throughout the day. It's just tough, but you got to try, because I believe that there's a higher level of scrutiny on an accused evidence.
And where we started to, just to tie it back, is this really is, for a lot of people, the first opportunity they have to be heard and to put their side of the story into the record.
100%.
So,
Well, hopefully this was helpful, and this responded to the question asked. I mean, there's so much more. I mean, it's hard to capture it all, but I think
Every
these
case
are
is unique.
Yeah, every case is unique, and we can't think of every possible question, but hopefully this answers the question of our viewer that wanted this segment, and you found it helpful. And our Pillow Talk says, please remember to don't forget to like, comment, subscribe, and share, even though it's in an inverted order, and keep sending us those comments and questions because it really helps. And
Well, as you can see, we're actually answering a request for a topic. So
good night, everybody, and
read
thank
them.
you.